Good afternoon to everybody. I'd like to begin by thanking Misny for inviting my partner, Roy Brighton, back to me to speak today, and to all the attendees who are participating. Just by way of quick background, Roy and I are both partners with Garfunkel Wild. Garfunkel Wild is the firm that is general counsel to Misny. Probably most of you have already heard about us by now. We've been general counsel for roughly the past 2.5, 3 years. Roy is co-chair of our litigation department. I happen to be a corporate attorney that works with a lot of medical practices. So I think between Roy's litigation background and my corporate background, you'll hear different perspectives on the subject. Roy and I will take questions at the end of the program. We do have a lot to cover. If for some reason your question was not answered or you just want to reach out to us after the program is over, our contact information, as you can see, is on the first slide, and feel free to either call us or email us. So Roy, if we can go to the next slide. Thank you. So as of this morning, when I checked the CDC website, I think that the statistics were inputted as recently as last night. The number of COVID-19 cases diagnosed in the United States was roughly 1,637,456. And the number of deaths is approximately 97,669. Today, we're dealing obviously with attendees who are New York based. Just to give you an idea of how New York State and New York City compare, in New York State alone, the state basically is responsible for 22% of the cases and roughly 30% of the mortality. In New York City, in the 5 boroughs, the 5 boroughs are encompass roughly 55% of all the cases in New York State and roughly 70% of the deaths in New York State. So clearly New York State and New York City are very hot areas where COVID is striking and having a higher morbidity and mortality. So we're dealing with a very, very highly aggressive virus. This is important. I'm not here to give, obviously, a program on a medical program to healthcare professionals, but it is important in terms of how you think going forward, in terms of how you operate your medical practice. We are dealing with a very highly aggressive virus with a mortality rate. Originally, when Roy and I started giving this program, it was approximately 5%. And roughly now it's about 6%. I think if you take the numbers that I gave you today, it's 5.96%. Since the start of the pandemic, we have learned a lot about this virus. We have learned that the virus has a long asymptomatic period where persons who are COVID positive are not manifesting symptoms, yet they are shedding the virus and are infecting others. And it is because the virus is so highly infectious that we need distancing. We now know that it's not only individuals who are elderly or those who have lung problems who are at greater risk, but also persons with hypertension, diabetes, obesity, and high cholesterol who are highly susceptible. Moreover, the virus can remain viable on surfaces, for example, for up to 3 days on plastic surfaces. This is why hygiene and sanitation are critical. We are learning more and more about this virus every day, and presently there is no cure. Antiviral and anti-malarial drugs have been touted, but the vaccine is anywhere from 12 to 18 months in the future. And again, these facts are highly relevant with respect to how you need to operate your office going forward. As a result of COVID-19, practices have had to terminate, furlough, or place employees on leave. Elective surgeries were either prohibited outright, as in New York, or they were strongly advised not to be performed, as in other states. Many practices started to use telehealth, particularly after some regulatory requirements were relaxed and with certain positive changes in reimbursement. Physicians tried to take advantage of federal stimulus funds or loans. However, with all that, a significant number of practices did not receive any loans, and many offices had to close, some even permanently. In the 3 months since we have been dealing with COVID-19, we have provided alerts and webinars on multiple subjects, including the Families First Coronavirus Response Act, the FFCRA, the CARES Act and its Paycheck Protection Program, the PPP. We spoke about issues relating to reasonable accommodations and disability-related inquiries and medical exams. We provided webinars on how to survive without performing elective procedures and how to implement telehealth services and dealing with risk management, billing, and reimbursement issues. We've addressed the enforceability of contracts you can no longer afford or comply with. And we have provided programs dealing with personal advanced care planning and healthcare proxies, living wills, and estate planning. These issues are not yet over. They are still relevant even as we advance to the next phase. For example, the FFCRA will still govern, as Roy will talk about, the emergency paid sick leave and the emergency paid family and medical leave. And how you terminate your employees and reduce salary and wages will impact your PPP loan forgiveness. We can go to the next slide, please. So what you need to appreciate is that back to normal is not the same normal we've had prior to COVID-19, at least probably not until we have a vaccine. And the three words you need to constantly remember are protect, prepare, and provide. You need to protect your workforce and your patients. You need to prepare for a COVID surge, and you need to prepare for PPE and staffing shortages, and you need to provide appropriate medical care. We can go to the next slide, please. So how do you begin moving forward with your practice? Well, first, you need to start with a detailed plan. And it will depend on the type of practice and the type of workforce you have. And since we are learning as we go along, even today, and things do change, the plan needs to be flexible. So first and foremost, and you'll hear Roy say this many times, you will need to comply with the CDC requirements, okay? And you will need to comply with the state and federal authorities. And this is very, very important because this will be helpful to insulate you. It's not a get out of jail card, and it's not a virtual guarantee, but it will help insulate the employer from allegations of either negligence or discrimination when dealing with your patients and employees. So again, you'll hear this many, many times during the program. You have to look at the CDC requirements, you have to be familiar with the CDC requirements, and you will have to comply with the CDC requirements, as well as any other state and federal authorities. You need to also take into account that we are still dealing with a stay-at-home order. So how does that work with resuming operations? And also, what if the federal, state, and local regulations have different or inconsistent guidelines and requirements? Which do you follow? So again, it's a difficult terrain that we're in. There are laws that you will need to comply with in terms of ensuring the health and safety of your employees. And these include the ADA, the Americans with Disabilities Act, which of course will govern and be relevant in terms of how you can question your employees about their medical conditions, their exposures, their travel, and whether you can take their temperature. We have the EEOC, which is the Equal Employment Opportunity Commission, which has issued guidance that addresses special accommodations. We have the FFCRA, which we mentioned, which still governs paid leave. And then there's OSHA, which is the Occupational Safety and Health Administration, which requires you to assure safe and healthy working conditions in your practice. And then there's a myriad of other federal and state laws that you're going to have to comply with. And the things you need to consider really can be divided into following three very broad areas. We have financial, we have operational, and we have human resources. I add cultural because frankly, the culture of your practice is going to change based on these three other bullet points. But the financial and operational are the topics that I will deal with, and the human resources Roy will deal with. And as you'll see, there is overlap. If we can go to the next slide, please. So as far as financial planning, before opening or rebooting your practice, okay, you need to consider and address various financial issues. By now, you may have already received and used all of your accounts receivables. You may or may not have received stimulus monies and or loans. And you have to realize that you will be dealing with a lower volume of patients, either because patients are afraid to come in or because you may not have sufficient PPE and staff. And many of your patients may be unemployed or do not have insurance. Moreover, you still need to pay third parties for rent, utilities, and vendors, and you need to take into account any unforgiven position of the PPP loans. So it might make sense to consider obtaining additional funding. This is something that many of the practices that we're dealing with are looking into. You need to sit down and assess your cash flow and create a financial forecast. You need to develop a budget, okay? Something else that I think is very important is you need to determine whether you can renegotiate some of your contracts so that at least for a period of time, they're not putting a financial noose around your neck. Perhaps you can effectively use your force majeure provisions in your contracts or the related doctrines of impossibility or impracticability or performance or frustration of purpose to either terminate or amend your contracts so they are more favorable to you. And Roy and I provided a program where we basically discussed how you can use these provisions, or in the absence of these provisions, or in the inapplicability of these provisions, how you can deal with the other party to a contract, whether it's a vendor, whether it's an employee, or some other third party, and see how you can either terminate that contract or how you can amend those contracts so they are more favorable, more likely the latter than the former. You also need to aggressively resume your collection activities and decide how you are going to deal with write-offs for the unemployed, the uninsured, and those with financial hardship. You have to decide how you're going to deal with your physician employees and their compensation. How do you treat a physician who makes a guaranteed salary versus a physician who's receiving all or part of his or her compensation based on productivity? What do you do about your older physicians? Do you discuss retirement? Are there buyouts? Can you afford to pay them? And if so, how and when? And again, so what this basically means is that you may need to amend your employment agreements with your physicians and with your key staff. You need to be very, very careful how you do this, okay? Because what you don't want to do is you don't want to create an impression that you are discriminating against certain physicians or certain of your staff members, either based on age, gender, or any of the other protected class status. And then you have to consider doing a phased opening, okay? And this will be based not only on your financial situation, but also on patient demand, availability of equipment, medication supplies, sanitary functions, and your staff. So when you do your assessment, okay, you need to assess how many patients will be coming in, what is your staff availability, what is your PPE supply, how do you prioritize your patients. You need to think about scheduling, you need to think about sanitary issues and hygiene, not only in your office and your office space, but in the building in general. And you also need to consider the emotional trauma of what's going on, okay? You will have employees who will have anxiety, who will have questions. You need to be sensitive to these issues. You need to be supportive of these issues, and you need to encourage communications, either with you and other members of your practice, as well as perhaps with psychologists and other healthcare professionals who can assist them. Okay, so these are all the things you need to consider. Okay, if we can go to the next slide, please. So as far as the operational factors, to ensure that your practice will operate efficiently and safely going forward, you need to address a myriad of factors, and these include, the first is PPE, okay? What kind of PPE do you need? Gloves, masks, eyewear, gowns, N95 respirators, okay? You will need to create guidance and policies on the use of PPE. Who should wear them? Physicians, staff, when? When should they wear them? Should they wear them only when they're exposed or at all times? And what about your patients? Now, a lot of this will depend on the specialty and how you deal with your patients. So, for example, a psychiatrist, may feel very, very differently in terms of how he or she's interacting with their patients, and may only feel they need masks, whereas an internist who basically is touching and palpating the patients all over, they will feel that they would have to wear gloves, eyewear, gowns, and perhaps N95 respirators. So depending on your specialty, that can have a different response. Roy and I basically feel that employers should provide masks to their employees. I think this is something very, very important. And as far as your patients, you should require them to bring masks, or in the absence of masks, they should wear some sort of a cloth covering. Okay, but again, what you're thinking about all these operational factors is the goal here is to protect your patients vis-a-vis each other, and to protect your employees vis-a-vis the patients in order to reduce exposure to COVID-19. And again, you always must follow the CDC guidelines for all of these operational factors. That should be considered your minimum standard. You will need to conserve the use of PPE. And how do you conserve the use of PPE? Well, you can reschedule elective procedures. You can educate patients and staff on the use of PPE. You can use telehealth. We'll be talking about that. What about considering the use of non-disposable PPE, and also perhaps reusing, your masks? So again, you should consider all of these factors. You should monitor the use and the compliance of PPE, and you should always make sure that you have an adequate supply, both generally speaking and also in the event of a surge. You need to be careful about theft prevention. We've seen many situations where people basically are stealing masks and other forms of PPE, and you need to make sure you have the appropriate vendors available. And again, we're going to say a lot of these things several times, so hopefully these will become more familiar. What about your waiting room? Okay, you need to make sure that the patients are physically separated by at least 6 feet. Sanitizers, tissues, trash bins, and masks must be available. Consider placing barriers to the extent you can. Remove or clean communal objects. So if you have magazines, or if you're a pediatric practice and you have toys, you may want to avoid having them all together, but certainly if you do have them, they should be cleaned. Have educational materials available. Put up posters about safety and prevention. And very, very importantly, is to limit non-patient visitors. And of course, you should disinfect the area regularly. Patients who are visibly sick should be separated. If medically permitted, and if you have the ability to do so, they can wait outside or in their cars. But if not, they should be placed in a separate location in the office. And of course, it's best to place them in an examination room as soon as possible. What about sanitary and hygiene? Well, you'll need to sanitize and clean between visits. Okay, this is very, very important, and this will increase the time between cases, and therefore must be taken into account when scheduling your patients. If you have a schedule that has 150 patients a day, it's going to be very, very hard to convince somebody who's looking at your practice because there was a complaint by either a patient or by an employee that with this type of volume of patients, you were actually sanitizing and cleaning between visits. So again, your schedule is going to be evidence, how many patients you're having is going to be evidence basically of how closely you were following the sanitary and the hygiene recommendations or the requirements. What about equipment, supplies, and medications? You need to ensure that you have an appropriate supply of PPE and medications. Equipment must be appropriately maintained. You must have backup vendors in place to assist in case your supplies run low. And again, this also will impact the patient volume. What about training staff? Well, what should you be training your staff on? Well, on how to use PPE effectively, on how to recognize COVID-19 symptoms, on how to triage patients, those that are acute versus chronic, those that are sick versus who don't appear sick. You need to train your staff on hygiene, including hand washing, and that they must stay home if they don't feel well. And you must document this training, okay? Because this will be very, very, very important in any sort of allegations and to defend you in any sort of liability. We can go to the next slide, please. So the next two slides are critical, how you protect your patients and how you protect your employees, okay? So with protecting your patients, we spoke about increasing the time between cases to allow for cleaning and preventing patients from being close to each other. Schedule your acute or at-risk patients at different times from those that are non-acute or who are not at risk or who are basically healthier. So maybe we found that many practices were it was feasible for them. Again, a lot of this depends on your practice. And again, this is not a one-size-fits-all. A lot of this depends on your practice and on your resources. But many practices were having success in scheduling their acute and at-risk patients either on the weekends or on the evenings. And that was a way to segregate them from perhaps the less acute and the less at-risk patients. What about beginning or continuing to offer telehealth services? Okay, many physicians are already using telemedicine or telehealth, and many patients will begin to request it as an option. Many of your patients have seen other doctors using it, have heard from their friends that they go to doctors who are using it, and have seen a lot of media publicity about using telemedicine or telehealth. Telehealth and telemedicine, by the way, we use these terms interchangeably, but telehealth is a broader term that includes telemedicine. If you do use telehealth, okay, and I think there will be an expectation by both your patients and perhaps even your employees that you should use telehealth in a way to better protect patients from each other and protect your employees from very sick patients, okay? But if you do use telehealth, you will need to create policies and protocols that govern how you assess which patients should be seen remotely and which patients should come in for an on-site visit. You need to be also aware of any of the changes in the regulatory requirements which may have been waived during the crisis. I mean, we personally feel that many of the waivers that we've seen over the past 2.5 months, that will shrink over time. Whether it's by the end of the year, or by the beginning of next year, or even sooner, you have to be aware of what's going on in terms of the regulatory requirements because we may see a change in those, okay? And also what happens if telehealth reimbursement is reduced, okay? How will that impact your decision to use this modality? Okay, you need to screen your patients. Screening is critical, and it should be done at least at 2 points. It should be done prior to the visit, and it should be done at the visit itself. Okay, so you need to screen your patients. You conduct a pre-visit telephone assessment, and you ask the patients about any recent COVID testing, whether they are manifesting certain symptoms such as fever, cough, shortness of breath, chest pain, sore throat, loss of taste and smell, nausea, vomiting, or diarrhea. Have a script, okay? Have whoever is basically doing the screening, they should have a script. And if a patient basically says that they're canceling because of some COVID-19 reason, that should be documented in the record, okay? Because now at least you know that there's a potential of exposure when they do come in. But you should ask the patients at the pre-visit about their exposure, about recent travels, about family members' health status. And then, of course, when they come into the office, You ask these questions again, because sometimes you find out actually more when you actually see them face to face, and you take their temperature, okay? Patients who are elderly or with underlying conditions such as hypertension, chronic lung disease, obesity, asthma, and any compromise of their immune system. For example, if they're a cancer patient who's being treated with chemotherapy, they need to be promptly identified and treated separately. So whether you identify them in the telemedicine encounter and or when they first come in, they need to be identified and treated separately. Symptomatic patients or persons under investigation should receive masks and be isolated in the office as quickly as possible. We do many times, many practices have asked us to prepare informed consent forms for their patients. So they're aware that if they do come in for an on-site visit, there is an increased risk of exposure. The consent should basically say that they were offered an opportunity for an off-site care, perhaps a telehealth visit or to defer their visit. Again, that may depend on the actual reason why they're coming in. You may want to actually have a listing of the adverse effects of COVID-19. You want to have some acknowledgement by the patient that they haven't traveled, that they have known exposure, either at home or at work, and also their patient responsibilities, that they took their temperature before coming in. They're willing to wait in the car. A lot of these informed consents could be online on your website, so they can see it before they come in. That they wash their hands, that they're going to keep social distancing when they're in the office, that they wear a face mask, and that they will call you if they leave the office afterwards and they find out they get sick. They will let you know. Okay. So again, these informed consents are very practice specific. The informed consent that we prepare for an internist is very different than that for an ASC, which is very different for a plastic surgeon. Okay. So again, a lot of these informed consents need to be very, very specific to the practice. To the extent you download one from the internet, that's fine. But again, you need to read it and to make sure that it applies to your practice. You don't want to have anything that the informed consent states something when in fact you're not following that protocol or that guideline. The patient services need to be prioritized, okay? Certainly in the beginning, okay? Those who need surgery or procedures, those who have high complexity chronic medical conditions, those who require necessary preventative services, they should get priority. And again, you reschedule non-urgent appointments. And as we go on in time, as things get a little bit more acclimated, we can be more flexible in how basically we prioritize and how we perhaps reschedule our patients. To the extent your practice can do so, it's a good idea is to use designated exam rooms and bathrooms for symptomatic patients. Again, not every practice would permit this, but to the extent you can, it's good to have one or two designated exam rooms and perhaps a bathroom that, you basically can allow those patients who are symptomatic, those patients who are COVID positive to use. If you have a separate entrance and an exit in and out of an office, that also can be very, very helpful. Again, you need to make sure you have ample supplies. We spoke about that. When patients leave, provide them with a detailed follow-up instructions, including about hygiene, masks, how to prevent the spread of infection. Consider a telehealth follow-up, okay? And you should notify the health department, basically, if you're dealing with a patient who has COVID-19 symptoms. Again, you have to work with the local health department, Department of Health. You have to be knowledgeable about COVID-19. There is a responsibility on your part to be aware of what's happening in your community and what the recommendations are. Do not refuse to see patients. Roy will talk about this too, okay? This can lead to a claim of patient abandonment. Again, the best way to deal with patients is you triage them on the phone. If you can use telemedicine, great. You triage them when they come in. And basically, it's very, very important to create, as we had said earlier, a script or a triage protocol, okay? Limit non-patient visitors, okay? Whether it's family members, depending on the type of patients you're dealing with. Obviously, if you're dealing with a pediatric practice, you will have to have a family member. But generally speaking, try to limit your non-patient visitors, specifically your cleaning crew, persons who deliver supplies. You want to reduce the amount of exposure to patients and staff. And again, as we had mentioned, be knowledgeable of COVID-19 in your community, the CDC recommendations relating to screening and management of COVID-19 patients. You can go to the next slide, please. So again, very quickly, because Roy will talk about a lot of the legal implications here, but as far as protecting employees, that's very important. How you protect patients will overlap with how you protect employees. So the screening that we talked about, putting them in specific rooms, all of that basically will ultimately protect your employees from exposure. So that's something that there is a lot of overlap between the two forms of protection, between patient protection and employee protection. But when you decide on how to protect your employees, these are some of the things you need to think about. Decide which employees need to return. And when they do return, do you have them come in different staggered shifts, maybe different days of the week, or for different divisions of your practice, if you have a large practice, or do you have them come in for reduced hours? Instead of coming in for 8-hour shifts, you have them come in for 6 or 4-hour shifts. Just like you screen your patients, you also need to basically ask your employees about symptoms, about exposure, recent travels, family members' health status. Okay, you might want to consider preparing a questionnaire that addresses these issues. Do temperature checks when they come in to the workspace. The ADA allows you to ask employees such questions, particularly if they are experiencing COVID symptoms. And the ADA also permits taking temperature readings, sending symptomatic patients home, and symptomatic employees home, and requiring a physician's note certifying fitness for duty. This should all be documented, by the way, and it should be kept confidential, but you want to document all this, again, to show that you are doing all these things to protect all of your employees and also protect your patients. So document and keep this confidential. Should you permit employees to telecommute? Well, the answer is it should be considered, and if so, you should have policies which describe which employees can do this and when this can be done. The policies should address scheduling, and they need to be flexible. Now, how will this impact their compensation? How will their work be monitored? These are all factors that we need to take into consideration. What about special accommodations? What special accommodations should you make for your high-risk employees? Those who have underlying medical conditions, including psychiatric or psychological, okay? These accommodations may include restructuring their duties, modifying their work schedules, allowing them to telecommute, allowing them to have leave, okay? Now, again, reasonable accommodations do not have to be provided if they result in what's referred to as undue hardship or significant difficulty or expense for the employer. You need to reduce the ability of employees to get together in the kitchen or in the conference rooms, okay? Limit in-person meetings and you must increase social distancing. Try to use as much technology as you can. Use physical barriers such as cubicles if you can. Separate employees from each other. Rotate employees. Use staggered shifts, as we mentioned before, or reduce the number of hours per day employees are present. All of this basically, is to protect the employees. You must monitor and manage those who are ill or were exposed. Send employees home if they don't feel well, and try to limit staff exposure to COVID-19 patients. Maintain records of staff contact with COVID-19 patients. Okay, and if possible, as we said before, try to use designated exam rooms away from other examination rooms. Okay, do you test patients before performing procedures? Obviously, if you're in a practice or an ASC that has a lot of procedures, the answer would be yes. Okay, do you test family members to make sure they couldn't have exposed the patients? Well, if they're coming in, that's something, if you're dealing with a pediatric practice, maybe you should ask about family members, certainly if they were exposed and if they've been recently tested and what their results were. Limiting visitors, we had mentioned that before. Reduce employees from having to travel to multiple offices. So for example, if you have a practice administrator, okay, who basically works at one office, don't have them go to every office basically during this period of time. Have them stay in their main location. If you have physicians or staff who tend to go from one office to the next, have them, to the extent you can, try to have your individuals stay in the offices to the largest extent possible, as opposed to having to travel to multiple locations and potentially exposing different offices, to COVID-19. Promote hand washing and other sanitary measures. Routinely clean counters, examination beds and chairs in the examination rooms, and furniture in the waiting area. Okay, in the waiting rooms. Your office should undergo deep cleaning once or twice a week, where all surfaces, computers, light switches, equipment, anything that people touch needs to be cleaned. And what's very, very important is that you must communicate all of these things, all of your preparation plans to your staff. Explain what you're doing and that your plan is about keeping the office safe and being compliant. And again, it's about keeping the office safe, not only for your patients, but keeping your office safe for your employees. They need to know what you're doing, because if one of them all of a sudden becomes COVID positive and they now blame the practice, at least you can say, well, look, we've done everything. This is what we've done for our patients. This is what we've done for our staff. And you have a preparation plan in place that you've been compliant with. So not only do you have to have one that you're doing, but you have to make sure you're implementing what you're doing. And you need to be transparent and show that you're committed, okay? So if we go to finally, this is my last slide before Roy takes over. So what will the overall culture look of your practice going forward? Well, there will be physical distancing. Patients will be screened more aggressively. Temperatures will be taken. There will be frequent cleaning and sanitation. High-risk patients will be treated separately. Patients and employees will be monitored for symptoms. Special accommodations will be made for high-risk employees, and of course, as required by law. Telehealth services may be provided. More patient and staff education, so you're going to have to basically deal with a lot of education, whether that's verbal or by signage. And you need to be prepared for a second wave of COVID-19 with sufficient PPE and staff. Okay, with that, I'll turn over the program to Roy.
Okay, thank you very much, Barry. For the rest of the program, everybody, I'm going to kind of try to go through a series of questions that I think most practices will have about human resources and liability-related issues concerning returning to work after COVID. So the first question I'm going to talk about is, and I think this is on everybody's mind, can a practice refuse to see a patient who had previously tested positive for COVID-19? And the answer is no. An outright refusal to treat or provide services to a patient who had tested positive for COVID-19 violates the Americans with Disabilities Act, the New York State Human Rights Law, and if your practice is located within New York City, the New York City Human Rights Law. That's not to say you cannot, that you're prohibited from screening patients or understanding patients' COVID-19 status. You absolutely should screen patients both before they come in through some type of telephone screening, when they make their appointment, and at arrival as to their COVID-19 status. Asking them questions about their potential exposure, their potential symptoms. You could even take their temperature. All of that stuff is perfectly appropriate. And based upon the information that you obtain, you can then make a determination as to how to appropriately treat them. You absolutely can take COVID-19 into account in developing a treatment plan. And you can provide services and alternative means to COVID-19 patients if that's what you believe is appropriate from a clinical standpoint. For example, if you are a psychiatrist and you have a patient who calls you, who tells you that they are COVID-19 positive, you do not have to have them in your office if you believe that through telehealth, through a telehealth appointment, you can provide the same level of services that you would be able to provide in an in-person visit. In that way, you're protecting your staff and you're protecting the patient from potential exposure and complications, but still providing medical services to that patient. So you have to look at each situation differently, but a blanket refusal that we're just, if you test COVID-19, we're not going to treat you, would violate the law. Okay? So those are things that I think you have to take into account. Again, you're certainly within your rights to test. You should screen. You should understand people's COVID-19 status when they come into the practice. You should treat them accordingly. Consider, for example, if patients with a COVID-19 positive status need to be seen in person, consider setting up a separate COVID-19 waiting area, special protective equipment, a unique exam room that just handles COVID-19 positive patients. That's all within your rights if there's a clinical basis, but an outright refusal would violate the law. Also, you can, in many cases, ban visitors from your practice, particularly visitors who are COVID-19 positive. Where you may not be able to do that is if the visitor is truly the patient's companion, the parent of a minor child, the adult child of an elderly patient who looks to the children to provide guidance. In those circumstances, you may not be within your rights to bar that visitor from your premises. And if that visitor is COVID-19, you're going to have to take steps necessary to protect them and to protect your patients and staff. Okay, but again, a blanket refusal to treat would be against the law. So the next question I want to talk about is, from an employment standpoint, what is the first question you need to ask before going back to work? And that question is whether or not you are going to give your employees the benefits that were established by the Families First Coronavirus Relief Act. Under the Families First Coronavirus Relief Act, which was passed and signed into law in March, there were federal paid sick leave benefits and federal paid extended family and medical leave benefits afforded to employees who work for businesses with less than 500 employees who have suffered as a result of coronavirus and have to be out of the office as a result of that. However, the Families First Coronavirus Relief Act contained an exception that said that healthcare providers can be exempted from the provisions of this act. Since you are all healthcare providers, the law says that you can determine whether or not you are going to allow your employees to take advantage of these benefits, the federal paid sick leave and the federal paid extended family and medical leave. It's up to you. If you decide to allow your employees to do that, then you get a tax credit. So to the extent that you pay out these benefits, you're supposed to get a dollar for dollar tax credit on the back end, payroll tax credit. So it should be revenue neutral for you, or I should say expense neutral, but it's totally up to you whether or not you want to do it. And that's an issue that you have to decide. All we are saying with regard to that is we believe you need to make a uniform determination. All your employees are going to be given these benefits, or none of your employees. If we start to pick and choose among employees, there will be some issues. So that's the first question you have to ask. Let's now go to the next. Let's talk a little bit about, in these slides I've given you, you can look at this at your leisure. I have a series of slides that go through the concept of what the federal emergency paid sick leave is and what the federal extended family and medical leave is. I'm not going to talk about these here today in the interest of time, but you can certainly look at these in your leisure and determine whether or not these are some things you want to offer. The key point is that if you do offer these benefits, again, you're supposed to get a dollar for dollar tax credit through a payroll tax credit at the end. You also have to consider New York State paid sick leave, which is a benefit if certain employees are out because of coronavirus related issues. And again, I have slides about that as well in case you're interested. So let's now go to, I think, is a key question that everyone is going to be asking with regard to returning to work and employees. And that's, what can you do regarding testing employees regarding COVID-19 exposure and symptoms? You absolutely are within your rights. The United States Equal Employment Opportunity Commission has held to screen employees for COVID-19 exposure and symptoms before starting each workday. You can ask employees whether or not they're experiencing symptoms of COVID-19. You can take employees' temperature. All of this is perfectly appropriate. The government has said that in these emergency times, it is perfectly permissible to do these types of medical examinations to employees as they arrive in work. The caveat is, though, is that if you intend to do this, you need to inform your employees in writing by either a conspicuous sign or a notice that you're obtaining medical information from your employees and it's going to be maintained in the employer's files. You need to provide this notice in order to satisfy your obligations under HIPAA and under the Americans with Disabilities Act. So once you do this, you're perfectly within your rights to do this testing, and we urge that you do so you understand what the COVID-19 status of your employees are. And to the extent that you collect this information, such as temperature readings from your staff, questionnaires regarding their symptoms relating to COVID-19, you must preserve the confidentiality of that information. It's protected medical information in a file separate from your regular employment file. So you have to create a separate medical file for your employee and put this information in there and maintain confidentiality of those records. Okay, now, kind of a follow-up question to the question I just posed is, what do you do if an employee tests positive for COVID-19 or tells you that they've had symptoms of COVID-19? Well, you can direct them to stay home. It is absolutely within your rights. All of the commentators and government analyses have said that employees who are positive for COVID-19 must stay home because they pose a direct threat to fellow employees and patients. So send them home. Now, when you send them home, they may be entitled to whatever sick time benefits they would ordinarily get under your practice's policy or under the law. And this is why I said at the beginning, you have to decide whether you're going to give federal emergency paid sick leave, federal emergency extended family and medical leave, because these benefits may be available to employees whom you send home. You also have to consider whether they would be entitled to New York State paid sick leave if they are sent home. These are all questions you have to determine. But again, if an employee tests positive for COVID-19, we think that the best course of action is to send them home immediately because they pose a direct threat to the rest of your employees and your patients. Okay, and when they're over their exposure or they feel that it's appropriate for them to return to work, you can absolutely require a medical note from them to establish their fitness to return to work. And we urge you to do that so you have documentation that a medical professional, not somebody in your practice, but an independent medical professional has determined that they're fit to return to work. This is an important feature because what it does is it shields and insulates you from liability to some extent if there's a claim against you that a patient, an employee, or a visitor was exposed to COVID-19 while at your practice. Relatedly, it is important for you to review and understand the CDC guidelines that have been issued for healthcare workers who return to the workforce after being exposed to or diagnosed with COVID-19. We are urging everybody to follow these CDC guidelines to the best of their abilities, because we believe that by following these guidelines are the best way to minimize your potential exposure or your potential liability for claims that a patient, a visitor, or employee was exposed to COVID-19 at your premises. Okay. Next question is, how do you handle fearful employees? There are going to be groups of employees getting these questions right now that are just simply afraid to return to work. They don't have COVID-19, but they're afraid to be exposed and they're afraid to return to work. Well, in that instance, when you're handling these fearful employees, the first question you need to ask is there any underlying medical condition that makes them particularly susceptible to COVID-19, or if they get COVID-19, makes them particularly susceptible to some of the very high-risk complications? If the answer is yes, because they have such things as chronic obstructive pulmonary disease, diabetes, obesity, other lung disease, they're immunocompromised, you have to consider whether that condition would constitute a disability. And in most cases, particularly under New York law, which has a very liberal definition of what constitutes a disability, if they have a disability, then you have to provide them with a reasonable accommodation under the Americans with Disabilities Act and under the state and potentially city disability rights laws. So if an employee is fearful of returning to work or they have one of these underlying serious medical conditions that make them particularly susceptible to COVID-19 or particularly susceptible to severe complications, and that underlying condition constitutes a disability, you need to provide them with a reasonable accommodation. And you need to engage in an interactive process with that employee to determine what the reasonable accommodation is. A reasonable accommodation may be allowing that employee to telework if the essential functions of their job can be performed remotely. That is probably the reasonable accommodation that's going to be the most discussed. And if you have an employee who can perform the reasonable functions of their job remotely, that's something that you should consider if they have an underlying complicating medical condition. If that's not the case, if they cannot perform the essential functions of their job remotely, you're going to have to decide whether or not there's reasonable accommodations that can be made to them notwithstanding that. For example, you may have to put them out on leave for a period of time until the COVID-19 exposure passes. You may have to limit their working hours. There are a variety of different potential reasonable accommodations that you have to discuss with the employee. Allow them to isolate when they're in work in a new office or a new special location so they don't come into contact. Don't let them treat patients who potentially have COVID. There are a whole host of potential reasonable accommodations that you may have to deal with. Also, you have to also realize that there may be some patients whose anxiety regarding COVID is a manifestation of an underlying significant mental illness, such as a severe anxiety disorder or something like that. And if that's the case, that too is likely a disability, and you're going to have to provide reasonable accommodations for that as well, in the form of telework, if that can be done, or in the form of other reasonable accommodations. And again, if you in fact need to send somebody home because of these disabilities, they may be entitled to sick or medical leave benefits. The end game is that if there are no medical or psychiatric bases for a particular employee's fear to return to work, you can require that employee to return to work. But again, you must exhaust all, you must satisfy yourself that there are no underlying disabilities that are motivating this. So if you ignore those underlying disabilities, you can raise some, you can have some particularly significant liability issues down the road. If someone's been exposed, send them home, follow CDC guidelines about returning to work. And the other thing you need to do, if an employee has been exposed to work, you need to enter that exposure in your OSHA log and follow all reporting requirements. Another question that is going to come up frequently regarding this is, many of you have furloughed your employees and are now considering to bring them back and reopening your office. And in the back of your mind, you're saying to yourself, gee, I may not want to allow every employee to come back. I may want to have a phase coming back because there may be certain employees that I don't think I have work for and I don't want to have the expense for, so I want to have a phased return to work. You can absolutely do this. You can have a phased return to work. You can limit who comes back to work right away. This makes sense from a lot of different perspectives. If you do this, however, if you have a phased return to work, you have to make sure that there's a legitimate, non-discriminatory, and objective business-related criteria that you're using to decide who's in what phase and returning to work. What you don't want to do is subject yourself to a claim that you're engaging in race discrimination, sex discrimination, age discrimination, disability discrimination by picking and choosing who's going to return to work first. You need to have a legitimate, non-discriminatory, and objective business-related criteria based upon the nature of the job, their skill set, whatever it is, you need to do that. If you're changing or reducing hours, you also have to make sure that that does not violate any employment contract. You also could consider, of course, limiting vacation, PTO, and other benefits for returning employees if that's consistent with your policy. Before you attempt to eliminate benefits, however, that may be vested, we urge you to consult with an attorney so you don't have a labor law violation. One of the things we talked about is allowing reduction in hours of employees going forward. You can certainly do that. You have to be careful, though, that if the employee is an exempt employee, which means they're a salaried employee, who fall under the administrative, executive, or professional exemptions to the overtime laws, you must ensure that the employee, to maintain their exempt status, earns the minimum salary threshold to maintain the exemption. And if you're going to change their rate of pay, their weekly wages, you have to do it at the start of the pay period. Here's some information regarding reduction of hours and unemployment insurance, which you can read out later. For the interest of brevity, I'm going to move on. Final question is, do you have liability as a practice for COVID-19 exposure? And the answer is potentially yes. your employees who could contend that they are liable for COVID-19 while working could file a workers' compensation claim alleging that they were exposed at work. Now, there are potential defenses to that claim related to the fact that there are many other potential sources in which they could have contracted COVID-19, but it still is a theoretical possibility. You may also have OSHA exposure for failing to maintain a safe workplace if your employees, one or more of your employees, contend that they were exposed to COVID-19 at work. You also could be liable to family members of employees who contend that they got infected from their family member who was an employee who got affected at your place. And you certainly can be liable to patients and visitors who contract or exposed to COVID-19 at the practice. So how do you limit this? I'm sorry, let me go back. You limit this through a variety of different things. First of all, you follow the CDC guidelines as best you can. Your best defense is to follow the guidelines. By following the guidelines, you will be able to best protect yourself from potential liability. That is the best way of doing it. Make sure that when you have an employee that tests positive for COVID-19, you follow them home immediately. Make sure you have personal protective equipment, all the other requirements to protect yourself from your exposure. The last topic I want to go is continuing a reduction of hours. There's also the flip side that many of your employees, you may be looking to work more hours because you have a bigger patient load now when you return to work because of the backlog. You have to make sure that for your hourly employees, if they exceed 40 hours a week, you provide them with overtime. And that's something where these slides will explain the overtime rules. So with that, I think we're almost at the hour mark. I know we wanted to leave time for questions. So I'm going to open up the floor for questions.
Okay, so we do have, Roy, if you look at the Q&A, we do have questions listed. And one of the first questions that I just want to, that seems to being asked a couple of times is, are we going to offer the slides? And is this program on the, is going to be on the MSNY website? I think I heard that this program is being recorded, so I think that it may be available on the MSNY website. But to the extent it isn't, please feel free to reach out to Roy and me, and we certainly will talk to you. We could certainly send you a copy of the slides, and we could do whatever you need us to do. Roy, do you want to take do you see the Q&A? Do you want to take the first question or a question that you want to answer?
Sure. So the first question I see is insurances are saying they will not cover business interruptions as there is no physical damage. Is there any recourse? And that's a question that many people are asking. We've done some presentations and discussions about business interruption insurance. The answer is that there's a lot of legal issues going back and forth with regard to business interruption insurance. And we're just at the beginning of the entire process. It's going to be months, if not years, before it all gets sorted out. Just because a carrier is denying you now doesn't mean that at the end of the day, you're not going to be able to get it based upon court decisions and based upon what laws get passed or governmental action. So the one thing that every practice should do is if they have business interruption insurance, make sure you actually file a claim related to COVID-19 business-related losses. There may be some insurers or some brokers out there that are actively discouraging their insureds to file claims. You should absolutely file a claim. You can't be in the game and get potential benefits later on if you don't file a claim now. So we urge you to file a claim right away. And you will get a denial letter if they're going to deny the claim. That is the letter that, if you think you want to pursue it more, that's the letter that should be sent to an attorney to look at to determine what your next steps are. There may be several potential grounds to challenge the denial, but until you get the denial, you really can't determine what your rights are. The next question is what should you do if a patient decides not to wear a mask, even though the patient was advised to wear a mask? And Barry, do you want to address that from an operational?
Sure. And by the way, to counter Roy's comment, if you do have a policy that you want us to review, again, call us and we can certainly go through the policy with you. As far as patients not wearing a mask, you know, we've had this encounter before with some of our practices. It's not very, very common, frankly, but two is you could give the patient tissues or tell the patient to use some clothing that they could put over their face, segregate the patient to some area of the maybe put them in an office where they could be separate from the rest of the patients in your location, depending on the waiting room, or maybe have the patient say, look, if you're not wearing a mask, you're going to have to sit outside or somewhere else, basically, until we're ready to see you. But we can't have you, you know, we don't want you to be exposed, you know, to the other, exposing the other patients. So I think a lot of this depends on, you know, again, depends on your practice, what your, you know, what you can do, what you can't do. But again, you know, if you have extra masks, then maybe you give the patient the mask. Obviously, you can't reuse that one. But I mean, again, there may be different different answers. Going back on the idea of, you know, and again, Roy, feel free to correct me. If you're a pediatric clinic and we say only one family member is allowed, let's say a mom or not a dad or vice versa. I always wonder why the dad has to stay in the car and the mom comes in. But putting that aside, you know, again, it's a reasonable thing to say. You want to, you know, prevent as many visitors from coming in. And if you have one parent and, you know, depending on the situation, the other parent doesn't have to be there, doesn't have to provide a history, doesn't have to provide any additional information. It is an appropriate thing to say, look, you know, obviously until this whole thing settles down, we'd like to have only one parent, you know, come in with the child as opposed to having two. For obvious reasons. We don't want the other parent to be exposed, and we don't want the other parent to expose others. So I think how you say this and the way you say it, I think will be very, very important. Roy, do you want to take a question?
Sure. So there's one question here, which is, so you can send a positive employee home, but not send a positive patient home. You can absolutely send a positive employee home. As I said, a positive employee poses a direct threat to the patients and the people in the office. So you can absolutely and should send them home. The issue of a positive patient poses a couple of different other concerns. The disability laws obligate you to provide services to patients notwithstanding their disability. And so COVID-19 positive exposure could be considered a disability. So a blanket refusal to treat a COVID-19 patient would potentially be against the law. If you have a patient who shows up in your office who's COVID-19, you have to make certain decisions. Is it clinically indicated to treat them in the office? Is that what's clinically required? Or can you, consistent with their treatment, say to them, we'll treat you remotely or from telehealth, because that would provide the same level of services given their condition as would treating them in the office. You really have to take it on a patient-by-patient basis. You also have to consider whether or not their COVID-19 status would prevent them from receiving the medical services on a clinical basis. For example, you know, if a patient is scheduled for surgery and is positive for COVID-19, you can deny them the surgery because clinically it may not be appropriate for a COVID-19 positive patient to have surgery because the complications outweigh the benefits in most cases. But you have to take this on an individual case-by-case basis as to what each patient needs and whether or not you need to treat them notwithstanding their COVID-19 status and whether or not you have alternative needs for treatment. Okay.
So another question that we hear a lot, and this is not the first time we're hearing this question, it's a good question, is what happens if you're a physician and you're working in an office suite that you're sharing with other physicians, you know, either of the same practice or different practices. This is not an uncommon scenario, and you have concerns that perhaps, certainly if you're dealing with other independent practices, that they may not be doing things in the way that you would like to do things. We have found that the two avenues that are the best is you approach the other practice, you explain to them that you know that you know we all have patients, we all trying to do what's best for the patients and for the employees. You also talk to the landlord to see how the landlord can assist in this regard. Certainly, to the extent the landlord has to do anything in the building itself, that's something that the landlord, should have responsibility for. But again, we found in more cases, more likely than not, that if you basically communicate your concerns to the other physicians who are in other practices that may share some of the waiting room space or maybe some of the corridor space, you can work things through. If not, then again, depending on the practice and depending on how you could maybe on the spatial orientation of your practice, clearly you may have to move people around. So that clearly, you may want to make sure that those patients who are not sick are not near any patients from another practice that could expose them. And again, this is really on a case-by-case basis. Talking about case-by-case, we are getting questions as to whether we have a template script, for screening or a template informed consent. Unfortunately, the answer is no. We've worked with many, many practices that are just very different from each other, so many times in the same specialty, but just different. The way they do things is very different. So we don't really have a template. Certainly, if you want to work with us in terms of developing a script or certainly an informed consent document, that's something that we can work with you on a one-on-one basis that's specific to your practice and that's consistent to the way your practice works and operates. Boy, we probably have one. We probably are running out, but if you want to answer one more question, that's fine.
Sure. So let me see here. The question is let's see try to see a question that a bunch of people have asked. We see sick patients in the parking lot or a drive-through. What legal issues does this bring? Well, obviously, I think from a standpoint of limiting COVID-19, that makes a lot of sense. If you're trying to limit exposure in your office, you have to decide a couple of different things. One, you have to make sure that there's appropriate privacy. You're not violating HIPAA by seeing somebody in a parking lot or a drive-through, that there's appropriate privacy protections. Two, you have to make sure that's a safe environment, that there's not other potential sources of infection for that patient if because they're being seen out in the open like that. But as long as you can satisfy yourself on both of those issues, that's perfectly permissible, and that's a good strategy in order to eliminate potential problems in the office.
Okay, and again, a lot of questions ask about, what happens if is there liability. Nothing you do is going to insulate you from 100% liability. Nothing is going to virtually guarantee that there's not going to be some issues. The important thing is to follow to the extent you can. Again, what Roy and I discussed, a lot of it was, it'll depend on your practice, what you can and what you cannot do. You certainly should comply with the CDC requirements and recommendations. We've talked about that several times. And do what you can do and document it and let everybody know that what you're doing. So this way, nobody can claim that they were not aware of the efforts that you were making to reduce, exposure and to protect your staff and your patients. And again, and document as much as you can. As we discussed, and that would be very, very helpful in case there are any allegations of either negligence or some sort of other allegations of misconduct. So having said that, again, we do appreciate you taking the time out on a Tuesday after the holiday weekend. We hope you all enjoy the weekend, and if you have any questions, please feel free to give us a call. We'll be more than happy to discuss your issues on a one-on-one basis and give you a more customized answer. So having said that, thank you very, very much.
Thank you. Have a nice day, everybody.